trip, and I'm going to check on it. Is anybody there? I'm going to slip in. Excuse me. Thank you.
better seats. I had better seats. But unfortunately, someone took it off, so I got it. So these, I think this is
know who has it. That's when, this way it doesn't go in. Say you bought it, somebody's using it until you retrieve it. You'll find enough information out of that. Have that.
I will. I don't think this is so far in the area, but I definitely will.
South Orange.
First, I want to thank you all for taking time and for busy schedules to be here. I know that this is a mandatory meeting, but I really do appreciate everybody's time and attention today. So we have a little problem. There's a huge accident on the thruway, and many people are stuck in that accident. Even though we already have an overflow room, it's going to overflow a little more. One of the people who is stuck in that is John Delgetta. I'm from Westchester. I have a few things I want to go over first, so we'll talk about that. The first thing I'd like to do is I'd like to start the day with a little gratitude. Obviously, this type of an event does not go on without people pitching in, and we have an amazing staff, and I would just like to give them a little love. Randy, Aaron, and Maureen Plainfield have done So why do we make this event mandatory for the company? Well, there's a couple of reasons. And the first one is, I do not want to lose my real estate license. Secondly, I don't want you to lose your real estate license and your livelihood. And lastly, we want to be known as the most professional and ethical company in the business. So we're always seeking to raise our ethics and our professionalism, and this is certainly one of the ways we can do it. Last week, I unfortunately had to write you a troublesome email about thefts in the company. I hope that you all got my very strong clear message that this is not acceptable. Small things are big, theft is not acceptable. It is not our culture, and it's not what we do. I wanted to add something that I didn't put in the email, and that's in the past, we have had associates with struggles, and they have come to me, and we have always helped them, because that's our culture. That is what makes us a company of integrity. And I want to thank all of you who sent me texts and emails and Facebook messages supporting the ethics that you know that we stand for. So I thank you, and let's have a little applause for that. The other thing I want to briefly touch on is safety. This week I had to send you an email about a very also troubling situation with a former customer threatening one of our associates. We take safety very seriously. One of the things that we did is we took the opportunity to photocopy our best practices that was come up from a joint task force of both market centers last year for best practices. I hope that you were given them today. I hope that you will all read them and you will all adopt them and implement them in your businesses every day. Another thing that we're going to be doing over the next month is testing a safety app. I'm going to ask now for a few people from each market center If you would like to be in the group to test the safety app, if you would raise your hand, okay? Randy and Aaron are going to take down some names. Okay, keep your hands up. The idea is if the app works properly, one of the things that we already know might be a problem is in some of our northern areas where there's limited cell phone service, there might be a difficulty with a phone app. But if it does work, our hope is that we will purchase it as part of our technology package that you're already paying for, and we will have that available for all of our agents to use. Because safety has to be a top priority for all of us. Do you guys have the names back there?
Yep, just one more second.
Okay, one more second, hold them up.
Hold them up. Gotta come up this way so I can see the hands.
So in the meantime, there's a couple of people I'm going to ask to stand because I want to recognize them. They are my partners, and they are our other principal brokers, Karen Saccone and Dulce Ferreira. Karen is out of our New City Market Center, and she has an office, a physical office in Pearl River in our business center. Dulce is, of course, out of Middletown. Karen is also the broker of record for New Jersey because we are licensed out of the New City Market Center in New Jersey. When I talk about coming to me today for different things, you can also go to either of these two ladies, and I want to thank them for their leadership and guidance. They handle a lot of questions during the year and give a lot of guidance, and we thank you for that. So any brokerage matters can always go to either three of us principal brokers that you can talk to. When we're going to be discussing law today, we're going to be discussing New York law. So I know some of our associates are licensed in New Jersey, so I want to make it clear that the law may vary there. So today is just about New York law. As a company, we now cover a vast area. We now cover Rockland, Orange, Sullivan, Westchester, Putnam, Ulster. We just out of Middletown joined the capital area region, which means we cover Albany, Saratoga, Columbia, Greene. For that reason, we have included, everybody should have gotten a list of all of the associates in each market center, along with their contact information and the areas that they cover. This way, it will make it easier for you to refer business. It's a real win-win for us if we keep our referrals within our own Keller-Williams market centers. And we will be updating that at least on a quarterly basis, and we'll post it out. Next, I have a housekeeping item. I'm going to ask for your undivided attention for the next 3 hours for our speaker. So I'm going to ask that you please shut off your phones and not look at your emails. Because what ends up happening is people are distracted, the speaker speaks on a topic, and then when it's time for questions, there are questions on what the speaker has already covered. And we have a lot of information to cover today, and we only have 3 hours. So hopefully everybody's business can wait. I know my business can wait for 3 hours. So I just ask for your undivided attention for the next couple of hours. We will have time for questions. In the past, we've opened up questions during the whole presentation. We're going to do it a little differently today, again, because we have a lot to cover. We have a big room here. So after each section, our speaker is going to ask for questions, and at that point, if you just hold it for each section, we will have time for questions. And now I see that our speaker has made it. So I'm going to introduce him. Our speaker is John Dalgetta. He is our corporate counsel and managing member of the Dalgetta Law Firm. Many of you are familiar with our beloved Ed Summer. He has been my corporate counsel even prior to Keller-Williams for about 20 years. Well, Ed is now basking in the sun in Florida for the winter. Ed is now of counsel with the Dalgetta firm, and he and John are very active in brokerage matters, including being counsel to the Hudson Gateway Association of Realtors and our MLS. John is a Pace Law grad, and he has a strong background in representing corporate clients in matters of contracts, e-commerce, real estate. John is respected within the brokerage community as a knowledgeable authority of brokerage law and has written numerous articles for Real Estate In-Depth, the HBAR publication, and Legal Lines, the NYSAR publications. So now I'm going to turn it over to John.
I believe that you received all of the course materials that probably all emailed to you. Yeah. Okay. Well, good morning. Happy New Year to everyone. We'll start off the new year fresh. We're going to revisit a lot of the stuff that went on in 2015 mostly. Also some new laws that will come into effect as of 2016. So, as Rotary said, I have been an associate with Ed Sumner since 2001. I became partners with Ed back in 2008, and we merged our practices. I took over his practice as of May of 2015. So Ed is up counsel to the firm. We've been representing the Board of Realtors and been representing the realtors for over 30 years. We actually incorporated the Hudson Gateway MLS back in 1976. So, and I've been basically taking over the reins on all real estate matters, corporate, brokerage issues, agency issues. So, again, thank you. Welcome, everyone. And we have a lot to cover. So what we're going to try to do is we're going to go through each section. What I've done is basically there's handouts, there's some materials. I'm going to refer to the materials. You don't really have to go through it. You're going to have a huge amount of paperwork that you can refer to. It's a very good resource. So if you have a question, you can go through. There's a lot of articles, there's a lot of outlines, there's a lot of points that you can go through step by step and you can find. And again, any questions, you can always direct it to Rosemary, and then she'll direct it to us. So we're going to start off. The handouts on this particular item are attached. We're going to really just go into the advertising highlights a little bit. That's our first topic. We want to focus on, and I'm going to just bullet point a lot of the areas. Obviously, you're going to have a lot of questions, so what we're going to try to do is at the end of each section, we'll try to open it up just for a few questions, because we do have a lot of material to cover. And by the time we get done, we'll be lucky if we can get through the material. But this is a good, like I said, a good resource. So even if you don't get, I'm probably going to focus on the most important items. If you don't get some items, it's because they're just not important, but less important. So for advertising guidelines, business cards. A lot of people have business cards. I see business cards handed out to me every day, and right away what I do is I pick out what's wrong and what's right with them. So we're just going to go quickly through. A business card must contain the business address of the licensee, the name of the real estate broker with whom the licensee is affiliated, and must contain the office telephone number for the licensee or the licensee's team. So that's a lot of information that has to go on the card, but it's required. If any of these pieces of information are not on the card, it will be subject to EOS discipline. The business card address, the business address, and that's the address of the brokerage firm. So only the addresses that are listed with the DOS as a valid address that's registered with the DOS and with the brokerage firm can be shown on the business card. If you have a branch office, if you have a home office, unless it's registered, you can't show it on the card. It has to show the brokerage address. And that needs to be reflected, and that has to be with, obviously with the brokerage firm that you're a licensee, that your license is associated with the DOS. Teams utilizing business cards must fully comply as if you're not a team. So whatever applies to the individual will apply exactly to the team. There's no difference. So when you're going through the regs and you're going through the materials that I've sent you, obviously you got to just make sure that take the team aside. If it's valid to the person, it'll be valid to the team. If it's invalid to the person, obviously it will be invalid to the team. If your name is Jonathan and you want to go by nickname John, I see this a lot, and I've seen actually the DOS discipline for this. You know, I've seen where person's name is Margaret, she goes by Peggy, okay? And if the card says Peggy, the DOS license, if it's registered as Margaret, you're gonna get a fine, you're gonna get discipline. You may not lose the license, because they rarely hold that for strict disciplinary issues, but obviously there will be fines imposed. And the more you get, the more violations, the more the DOS will go back into the history and see how many violations a particular agent has gotten. So you gotta just be careful. So if you have, you know, a nickname, if it's John or Jonathan, just make sure that you have either John in quotes, or any other name in quotes. You don't have to register that nickname with the Department of State. You should have it in quotes, but if you have to have, no matter what, as an element on the business card, your name, the full name as it's written on your pocket card. Again, if you follow the DOS best practices, whatever your license type is, this is another issue. A lot of times you just want to put sales associate or real estate agent. You have to follow exactly what the DOS has on record. So if you're a licensed sales associate, that's what you put on your license. Licensed real estate broker, that's what you put on your license. We'll get into some titles and stuff later on, but basically you just have to be wary of these issues. Signs. Signs are another important element because it just, and again, you may know all of this stuff. This is just really a refresher course on what you do know. If you don't know it, it's obviously new information and you should, you know, make sure that you're aware of the regulation. Unless a local law provides otherwise, any signage placed on a property must identify the representative broker or brokerage firm. So obviously if there's teams, you gotta make sure the brokerage firm is on that sign. In the materials it says signs, for sale signs, that just omitted to put for sale signs, but for sale signs are not required to include the address or phone number of the broker, okay? So basically, and the reg 175.25 is very clear. You can, you know, refer to it in the materials and it tells you exactly what you can do and you can't do. However, if the sign is going to include phone numbers, so if you are going to put a phone number on a sign, a particular sign, that of the brokerage, or any advertisement for that matter, you must identify the type of the phone number that it is, whether it's an office number, whether it's a cell number. You actually have to note preface those numbers by either cell, office, or home, whatever it is. Directional signs for open houses, they are not required to include the name, address, or telephone number of the brokerage firm. But again, if you do include it, then obviously the other sign regulations that I just pointed out do apply. So anytime you include additional information, you have to comply with the regs. So basically, if you have an open house, you can just basically have either the brokerage firm name with, you know, a directional sign and an arrow saying open house, you know, this way. If a licensee includes his or her name or a team name on the directional sign, then again, the brokerage firm must be listed. So if you have for sale signs, it's probably going to just say to Keller Williams, you know, the name of the brokerage firm. But it's not, if you do anything that has a team name on it or a name, you have to include the brokerage firm first. Trade names, these are usually another issue that we deal with a lot is trade names. Many brokers form an entity under a particular trade name. When you form an entity, whether it's a corporation or an LLC, you're going to name it some name. You're going to name it, you know, 123 Realty, LLC, something to that effect. However, sometimes you want to DBA as a separate name. Usually under a franchise, you're going to DBA as Keller Williams something Valley. You're going to do a lot of different things. Those DBAs have to be approved by the DOS. So if you're going to register any DBA, if you're going to have a corporate name, make sure that the license is also submitted under the DBA so that the DOS, you will get fined. And a lot of times, the fine doesn't come up because you don't comply with this. The fine comes up because you got to get either a grievance, complaint filed with the DOS. The DOS investigated officer usually will send me a checklist as the attorney a lot of the brokers will contact me and then say, what do we do? And there's a huge checklist that the investigator wants. And some of those items are gonna be things of, whether they want a business certificate or an incorporation, they wanna make sure, the section 443 has been given. So they'll give me a list of information, and they'll look at all that information and not only focus on what the complaint is focusing on, they'll also issue additional violations at the same time. So they're not gonna limit it to what the complaint is, but they'll also find if they see that your business card is wrong, or they see that you're not filing with the DBA, and the DBA is not approved, obviously you'll have additional ratifications and violations there as well. It's not a new requirement, okay? Any doing business ads, you should have the corporate name and also the DBA name followed by it. It's not new, this has always been there. Brokerage firms are only permitted to advertise under the name that appears under the DOS license and registration. If the corporation or LLC operates under an assumed name, then you have to file again to obtain a license under that assumed name. Every salesperson licensed with the firm must also be licensed under the assumed name. So again, if you're licensed and you're a salesperson, you have to be licensed as well. When you're filling out the salesperson application, that it designates the DBA as well. And again, DOS investigators usually are looking at this stuff. They really look at it. I've had a lot of investigators that I deal with. We're focusing on one complaint, and all of a sudden they call me and say, John, there's a ton of other things wrong with this issue that have nothing to do with it, and then we have to address those issues as well. In the end, we normally, hopefully, don't go to trial. We don't have to meet the administrative law judge. We can try to settle it with the senior attorneys there at the DOS, but it's something that you have to always keep in the back of your mind. And again, any entities, you just have to make sure you're operating in accordance with the law. So if you have any questions or you feel like you're not, obviously you direct it to the correct personnel in the firm, and make sure that they, if they don't know the answer, certainly will provide, the information that you need. So again, if you go through the materials, I'm just going to go quickly through Reg 175.25, just to say they have the definition of advertising, they have the definition of teams. I'll get back to this later, but the definition of teams in here is a reg. There's actually no definition in the real property law, which is kind of weird. When the DOS instituted the name, the definition of a team, they did not change or amend the real property law to include the same definition. I'll touch upon that later on, but there's a definition of what a team is, what the real estate brokerage means, and then basically it goes through and it really outlines exactly what you need to do. It has placement of advertisements. 175.25 is very well written, pretty clear to follow. Placement of only a real estate broker is permitted to place a sign, to place or cause to be published advertising relating to the sale of real property. That's right out of the statute, out of the regulation. Advertisements placed or caused to be published by an associate real estate broker, real estate salesperson, or team listed with or represented by the real estate broker are not permitted except where the property is listed with or represented by a real estate broker within the associate real estate broker, the licensed real estate salesperson, or the team is placed in the ad. We have to make sure that we follow this. You have authorization also for advertising. No property shall be advertised without the express written consent of the seller or the owner of the property. Real estate brokers shall not advertise property that is subject to an exclusive listing held by another real estate broker without the permission of the listing broker. So those are just some, tidbits of information. Some of the contents of advertising: name of the real estate broker, name of the associated licensees. These are all different subjects under the 175.25. And again, it's part of your materials. It's not in the bullet point here on the presentation. Nicknames, these are all just some of the things that are questions on the license type. The express contact information has to be in compliance with the reg. Again, home offices, the only time you can have a home office is registered with the DOS as a home office or a branch office. You can't have that on your card, basically saying they have a home office, because you're misrepresenting and it could lead to a DOS disciplinary action. Telephone numbers, again, we went through that. Logos, if the team has a logo and you want to show it, you still have to show the brokerage firm logo as well. If the team does not have a logo, you have to show the brokerage firm logo. So that's basically just a quick, thing to think about. To go back to your business cards, flyers, whatever ads you have out there, you got to make sure they're really compliant with these types of threats. I know it's a lot of information to take in, but again, this is stuff that, is evolving. We have some new brokers here, older brokers, and believe me, some of the older brokers don't know, a lot of the stuff either, and they'll come to me and call me and say, John, what do we do? And that's basically, what we outlined here. Again, there's articles that Ed has written, that I have written. I've made them part of the materials. One of the articles that are included in the materials is entitled Business Cards and Signs. If you want to use that, that's basically an outline on what to do and what you need to refer to when you're basically figuring out what you can include on a business card. Again, some of the highlights, the advertisements must include the name of the real estate broker or the brokerage firm. Advertisements must reflect the name of the license status under the DOS, nicknames, all that type of stuff. It's all included in the article. And I use it, you'd be surprised, a lot of times a broker or an agent will call and say, John, what do I do? I'll send them the article to you. And then by the time they're reading it, they're like, great, I know exactly what to do. So it's kind of a good resource. I would, encourage everyone when you get the real estate disaster, the real estate, there are a lot of very valuable articles in there, especially the 9-Star Legal Lines has a lot of valuable information, and they keep up. So, a lot of this stuff is really all legal related, and obviously you try to write in a way where everybody understands it, so it's not, really over your head. And again, there's also an answer published by Anthony Gatto up at 9-Star. He's 9-Star's in-house legal counsel, general counsel there. And basically there's a question and answer, a Q&A form that he's handed out. And usually they answer pretty much all of the questions. Some of them, can my broker have a different advertising requirements other than those found in the regulation? He provides a pretty strict, yeah.
I just want to state that everything that John's saying, all the materials here are great guides. But you have to remember that everything that you do, whether it's business card, sign, and ad, must go through our compliance. Okay, so we have our compliance maven in New City, Diane Carroll.
She needs to speak all of your time. Yes, give Diane a big round of applause. And in Middletown and in Rock Hill, it has to go through Aaron there. So right now.
Yeah, and just to stress, nothing in here, obviously, all has to be approved by the broker. Okay, so no advertising, no business cards, can be done anyway. So I think we lost it. Okay. Yeah. So we'll keep going. So that's basically, in a nutshell, some advertising, some tidbits on advertising. Okay. We also have trade names. Again, we went over those. Let's go over those as well quickly. So many, again, many brokers form an entity under a particular name. and have, and then do business, you know. In the context, just so you know, we have, we did all of the crazy register after that, I don't have the slide. So let's go. So after that section, I'm going to open it up to some questions, if anyone has any questions.
Any questions? I have one question. Where are all the handouts you're referring to? Are they in this 300-page document somewhere?
Yes, yes. They should, and I think I sent out a revised package. So if you got an initial packet, Rosemary will send out a updated packet that actually puts the handouts right after each section rather than in order at the end. So it'll be easier. You'll get to the end of the section when you get the new package, the revised package. All I did was basically just put the handouts right after each section so that it's easier to refer to.
I know New City got the revised yesterday. I'm not sure if oh, okay, you didn't. So Middletown and Rockville, you will get the revised package.
Yeah, for purposes of today, you don't really need to go through the materials, but they are all there. They're all available. The only one article that I did not include in the package, which I just I'll email separately, is just an article that I wrote on the lead paint. It's really, lead paint, as we all know it, there hasn't been really a huge change, but I'm also going to email that. It's a legal line article that I wrote back in 2008, and really outlines the procedures and what we need to know about, you know, lead paint disclosure. So we'll get to that when we get to that section.
Here you're not referring to, John, when somebody forms an LLC or an S corp, they get paid from the broker.
Yeah, we're not talking about that yet. Okay.
Somebody else have?
Let's say the DOS investigator finds something that is wrong. What is the typical fine? And then also, does errors and omissions insurance cover that?
Good question. I can tell you errors and omissions will cover it. Whether the brokerage firm wants to put in a claim on the errors and omissions policy is a different story. Rosemary, I think, has a little comment to that, and then I'll get to the legal.
So I've been a broker for 20 years. Kudos to all of you, because we have only had a handful of complaints to DOS, like less than 5 in 20 years. Okay? We have only had one fair housing complaint, and we have only had one arbitration in the Board of Realtors. And all of those were not found to be in any way viable for our offense. Okay? So what I can tell you is, we've never had to deal with that, and I hope we never do have to deal with it. But we do also have a $2,500 deductible. Okay, so in our P&G, any deductible has to be met by the agent if you are found to be in violation first before we would collect on our E&O insurance.
Yeah, just from a practice.
My question is for Rosemary. If it goes to compliance, whatever, business card, can the agent still be held responsible by?
No, if it goes through our compliance, it won't. But the complaints that we've gotten have been about activities, license activities, things like that. Not so much that a sign wasn't in compliance or things that we're checking. So.
Yeah, and just back on the point of whether, you covered on the DNO. Most DNOs will cover it. Obviously, this deductible they have to take into account. Most of the brokerage firms that we represent will call us and say, we're not going to put in a claim, John, can you just handle it or, deal with it. And normally, if it's not a huge violation, you're dealing with a fine, $50, $500. It's not the end of the world. They basically, if you need to take some additional CE courses, they'll put that into the settlement agreement with the DOS. But for the most part, thank goodness, when they call us and we try to knock it out on the first round, I just got an email yesterday morning where we submitted an answer And just so you know, I mean, thank God there's only 5, but I have brokerage firms who literally call me almost once a week, and it's bad, but, so we can see from, exactly, we can see, you know, if there's only 5, in the history, that's not bad. But what I can tell you is when they do call, you know, I have to meet with the client, I have to meet with the brokerage firm, with the licensed salesperson, and with the broker, or the managing, you know, member of the firm. And then basically what we do is, I try to, you know, a lot of times there's emails. The important thing is I'll give you one example that we've worked on. There emails and text, I mean, they're just horrible. I try to tell people they're good in one way, but they're very bad in another. There's just so much information that sometimes the brokers will say, I didn't do anything wrong, and I'll get text messages that go on for weeks and months, and the person has become that person's agent, you know, representing a buyer where normally you wouldn't, you did the email exchange. So I try to look at it, and I try to turn the response in such a way where we just focus on the issues and try to get it kicked out at the investigator's level. If you can do that, normally it just gets kicked out. If the investigator sees that there's any additional, or can't really make a decision as to one way or the other, it gets bumped up, and it gets bumped up to the attorneys at the DOS. At that point, it gets, you know, a lot more involved. The DOS attorneys are going to require a lot more information. And you know, I can tell you, we sent a response in 15 days ago, already got it dismissed on the investigative level. I sent a response in on just a horrible fact pattern, and the DOS investigator, who's the same one who dismissed the other one, 2 months later, still not dismissing it. So, you know, you just have to be careful, and that's basically, you know, most of the brokerage firms, they'll just pay us to take care of it. You know, especially the firms who have a lot of, you know, violations and don't run their operations the right way, or, you know, a little lax. The more you put into claims, the higher your E&O is going to go, and the likelihood of you renewing that E&O application, you know, policy next year is going to be, you know, slim to none. So that's just some, you know, and I'm going to try to give you some personal experiences too. It's not just learning this stuff, it's knowing what they actually do. I mean, it's great that we have all of this stuff, but sometimes the DOS, I can tell you, Ed and I, we've met with Whitney Clark. We go up to the NISAR conferences twice a year. We go out to Chicago once or twice a year, out to San Diego. We meet with all of these people. And a lot of times the DOS investigators don't even know the law. You know, I have to actually pull out letters from Whitney Clark or letters from past, you know, senior attorneys saying, they basically said this was okay, and you're saying it's not, and then they'll go back and they'll retrace their steps and say, okay, fine. I had one instance where the senior attorney said, I don't care what the prior attorney said, this is what it is now, and you have to follow it. So, you know, again, it'll help. It's good that you have that background, but each case is different. Sometimes where you can get a dismissal on one, and on the same fact pattern, you get an investigative officer who just won't make a decision and send it up right into the attorney's case. So you just have to be careful. Section 2, we're going to do a little bit of an agency overview. And again, a lot of times people like us and real estate brokers, we forget that we're fiduciaries. You know, we represent attorneys as well. So attorneys come to us, and Ed was on the grievance committee for many years. Was the chairman of the 9th Judicial District grievance committee, and a lot of attorneys will come to us because they have a grievance against them. So it's basically along the same lines as grievances and complaints against DOS licensees and brokers. So what happens is basically they'll come to us and say, you know, what did I do wrong? Well, you're an agent, and there's specific duties that agents have. I mean, obviously there's different types of agency, but for the most part, if you're a fiduciary, you're a fiduciary. You and I are held to the highest standard at law. There is no higher standard than to be a fiduciary of your client. And that's what we're held to. So when the DOS sees that you may have had a dual agency situation and did not disclose it, they come down hard on it. Sometimes they'll take the license away, sometimes the fines will be, hefty, the continuing education requirements will be hefty, but, they don't like the fiduciary responsibilities, because those responsibilities have not changed. A lot of this law changes every year. I mean, we're up there, NISAR does a great job, the Hudson Gateway does a great job at, political action and trying to get laws passed or defeated. But sometimes, we forget about the agency and why the agency is out there, why the disclosures are required. These are all required disclosures. They're all right in the law. So when you see that agency disclosure, the buyer and seller disclosure, that actually, if you open up the law book, there's a page in there that shows the disclosure. It's not that the DOS came up with it. This is part of the law. So that form comes out, and we'll, basically, under RPL, and a lot of times it's called Section 443 disclosure. We need to provide that form to a seller or landlord prior to entering into a listing agreement. So that's the most important thing. Over the years, the DOS has held first substantive contact. Okay, 2 years ago, before the email thing and before the faxes and all of this kind of stuff, there was a real, determination factor of what, made up real, first substantive contact. They came up with this warm body contact. What does that mean? You'll know it when you see it. You're talking to a landlord, you're talking to a seller. They come in, you start, they tell you we want to retain you. You basically want to sell property, you get into the nitty-gritty. That's substantive contact. You have a request. What do you guys charge? What do you do on a listing? And it's just an informational request. Obviously, you haven't stepped over that line. With email, texting, that really is, warm body doesn't apply anymore. Now it's really back determinative. If there's emails going back saying, yeah, I'm representing you, and you didn't give a 443 disclosure, you're going to be fine. You may, and I've seen licenses just on text basically taken away because, a client comes in, reads, says they represented the seller, but they also represented me. And there's a text saying, don't worry, I have your back. I mean, literally, that was one of the questions. I'm taking care of you. If you're not a buyer's agent, you're not taking care of the buyer unless you actually disclose that up front. You have to have this, so I always tend to go on to the conservative side and say, if you're close and you know it, have it signed, have all of the documentation signed at that time. And again, you go through compliance and make sure, Rosemary runs, a stellar operation. There's usually not a lot that I have to tell, but when I do the smaller brokerage firms or the, mom and pop type of firms where they have 4 or 5 or 6 agents, I can tell you there's a lot of, representation of brokers in the Bronx and the boroughs. The Bronx has actually gotten very good. And I can tell you why, because they've actually become members of the HGAR, the MLS, and they've become members of the Hudson Gateway. We're not part of them. We don't represent them as an official region, but they are a substantial part. Richard Haggerty reported on Monday at the Women's Council that they make up, we have 700 registered members from the Bronx. I can tell you when I started doing this 20 years ago, the Bronx was the Wild West. 443 disclosures, I don't even think they knew what it was. And they've been around for years. So you have to be careful. Again, this is stuff that you may say has second nature, what we're doing, but be careful. Person that I told you that we're waiting for the DOS investigator to dismiss it, and hopefully we can, his text messages are not good. And I didn't give any text messages to the DOS investigator, but I did specifically go through and address each of them in the response. If they come back and they want to see them, I made as best an argument as I can for say that he's not. But if they do request it and it goes to the next level, there's really not much I can do. They can subpoena those records, and unfortunately, text messages don't go away when you hit delete. Okay. I have a client who called me just the other night. He's getting not even a grievance. He's getting sued in small claims court for an saying, I'm gonna reduce your commission at the closing by $2,000. Obviously, my client says it was never said. There is an email coming from the buyer's agent, from the seller, I apologize, to the buyer's, to the selling agent, saying, please confirm, that you're gonna give me the $2,000 credit. So there was some sort of communication. So when the broker tells me they didn't talk about it at all, obviously there's something there. So, and that's the licensee, the broker, the broker of the firm called me, and basically, I told him, I said, listen, he may not see the email, he may not remember responding to an email, but there may be a response. I mean, everybody's so, you run around day to day. I'm going to take questions. Go ahead, I'll take the quick one.
In your opinion, is first substantive contact always in person? Always in person?
No, that's why I'm stressing with emails, with phone calls. A lot of times we do stuff, and even myself as an attorney, I engage people through phone, through email. I send engagement letters, via phone and email and fax. So these days, if there's enough information, it's very fact determined. So it's fact-based. The investigative officer or the attorney at the DOS, or even in court, if this goes to litigation, a lot of times we do side by side. We represent the brokerage firm and the broker. But I'm going to get to it. I stray a little bit, but we don't have that much time. We're going to try to take a break at about 1:45, or is that good? So yes, it's very fact determined. Substantive contact isn't the warm body contact standard.
Okay, so just piggybacking on that then, if you're going back and forth with email, then at what point are you having them sign a disclosure?
It should be as soon as there's talk about listing, price, commission, and that basically we're going with your firm. That's substantive contact. It could be even less than that. And I can't tell you what it is because I've seen DOS attorneys say that there's an agency relationship on even less than what I just said. So it's really, what I suggest is just make sure that you're very clear when you're dealing with it.
I think the bigger question is on the buyer's side. Okay, the buyers call up and are talking to
our agents about a particular property. I think clarification on that as to when they should give disclosure. If they're asking the buyer for a pre-qualification, or they're interested to see the property, our agents are going to ask, are you pre-qualified? Okay, so at what point should they be giving disclosure?
The agent asking for pre-qualification, you're still acting on behalf of the seller. You gotta get in that fine line where you start saying, oh, I'll refer you to my mortgage broker, which happens all the time. I'll refer you to an attorney. Okay, little things like that. So I would tend to stay on the side of, caution and basically provide the disclosures. If you're representing the seller, make sure that if there's a buyer that comes in, that you disclose to that buyer immediately that you do not represent that buyer. Unless that buyer says, I would like your firm to represent me, then you would have to go back and have a disclosure already signed by the seller saying that you're just the seller's agent. If there is a buyer, it's okay. I usually don't use the PowerPoint.
Yeah, and the next thing would be, what would be the best practice for open houses and getting disclosure?
Yeah, open houses, the DOS still takes the position that it has taken over the years. DOS right now is still saying that if you do open houses, you're not required, unless there's really negotiation that takes place at the open house. If it's strictly informational, you don't need to enter into a disclosure rate provide disclosures to every person who walks into the open house. You can do a roster, you can have follow-up. But the minute there's negotiations, you really have to make clear to whoever provides any, if there's an offer made, and a lot of times, I try to tell, and I know everybody deals with it, believe me, it's not, I don't know how you get around it, but a lot of people deal with texting. And the minute you start going back and forth on text, believe me, you don't need an attorney to figure out whether you feel something wrong. I can guarantee you, you don't have to say, John, is this wrong? If you're talking to a buyer and you're basically taking offers, submitting it to the seller, going back and forth, then giving additional information, you know that there's a disclosure that's required. You know, at that point, you have to, because believe me, as we as a fiduciary, we're held to that standard where we need to make sure the public is aware. This is what I do. This is what I'm doing. I'm a seller's agent. I'm not your agent. You know, and buyers don't understand this. And you know, giving them that form doesn't hurt you to give it to them at a point where you think maybe too early. You don't get penalized for disclosing too early. You know, if you over disclose, it's great. You know, my mantra in my office is CYA, right? I do letters to CYA every day, and you know, I do it with existing clients who I know understand what's going on, but I want to make sure that they don't come back later on and say, you know, you didn't tell me that, John. And then I pull out my letter and I'm like, I did. You know, and you signed it, and you acknowledged it in an email. So it's kind of, you know, that's, so you use the text, you know, maybe have a little disclaimer. I'm again, please note I'm representing the seller. I'm not representing you. You know, I am only taking your offer and presenting it to my side. You know, and we'll go through. I'm going to go through one of the articles here. Goes through what, you know, and I you know, remember writing the article with that. We go through what the fiduciary responsibilities are, and you really, you know, once you know it, it's really a gut check. And if you really don't understand it, or you're saying, what do I do? Who do you call? Rosemary. And then Rosemary will say, something, and then she'll call me. But, you know, that's really, you got to be in the compliance officers. I mean, they're the ones who really take this to heart. They're in charge of compliance.
Yeah, and on that point, whenever you have an accepted offer, you know, within 72 hours, you have to get that into our .loop system. We are expecting compliance at that point that you have the disclosure form signed. And the same thing with your listings. You're supposed to have them within 24 hours, have up to 72 within our P&G. We are expecting you'll have disclosure form signed then too. And it is our policy to get advanced consent for dual agency. We do have a lot of Keller deals, so we want to make sure we have that dual agency in place. And just remember, if you do have deals that are Keller with either myself, Karen, or Dulce, there is no designated agency on that, okay? It's just a straight dual agency because we are principal brokers, so we can't be designated for either one.
Right. Yeah, and I'll touch upon that, but like Rosemary said, it's really, the brokerage firm or the brokers are, you know, the overseeing party of everything. So it would be the two, you know, salesperson in the office that would be either a buyer's agent or seller's agent. So let's just go quickly through the bullet points. You got to give the disclosure form to the seller or landlord. You know, at the absolute worst, prior to any listing agreement being signed. Okay. So obviously, if there's procedures in place in the office, you're going to just follow the procedures. The form must be signed and a copy given to the seller or landlord unless there's a refusal to sign. A lot of times you don't know what to do. You know, if they don't, you know, they don't want to sign, or like we don't want to sign. The law actually takes that into account. The law allows if the seller or landlord refuses to sign a disclosure form, then basically a written declaration of the facts of the refusal, and so you just write down, you do a quick memo to the file. You write down what you did, what led up to the circumstances, and then you provided the form. There's an email in the file saying I'm not going to sign the form. That's fine. You take it, you attach it to the memo, and basically you have to keep it for 3 years in the file. Okay, and that's usually, I would say, 3 years from the time of the engagement. If it closes, make sure you keep it 3 years from the time it closes, just to be on the safe side. So basically, keep it in the file. So if there's ever any disciplinary action, obviously 3 years isn't, tomorrow's the third, the first day of the 4th anniversary, you take it and you shred it and you have no records of it. now with the cloud and with, encrypted servers and stuff like that, you're probably gonna keep it for a lot longer. I can tell you when I did the merger practice with Ed in May, God knows, Ed and I used to keep everything. We have files, I have a storage room that's just filled with files, and we're obligated to keep them over 7 years. We have files for 51 in there. Why? Because we keep the client. We're still representing the client. If something comes up, and you bought a house 20 years ago, we still have the closing file, so that if they sell, they'll call us. That's the thing, but the law requires just a minimum of 3 years. Similarly, a buyer's agent must obtain an agency relationship disclosure form from the buyer before agreeing to act on the buyer's or tenant's behalf. Okay? So, I'll get to this probably in some of the, I'm going to touch upon it probably all day or all morning. But again, agency, agreements to represent don't have to be in writing. Best practices say you should have everything in writing. Listing agreement should be signed. There's verbal listing agreement, verbal contract. So if an agent represents a buyer and basically, there's an exchange that says, yeah, I'm taking care of you, and the buyer says, great, you're my agent, that's it. There's no requirement that you have to have anything in writing. That's why we put all of this. That's why the laws really want you to disclose this, because the minute you don't have this stuff in writing, it's going to lead to lawsuits. You can deal with a DOS complaint and try to get through that, but when you're dealing with a lawsuit, alleging, hundreds of thousands of dollars in damages, that's going to cost a lot more than a couple of thousand, to fight a DOS, complaint. And those DOS complaints sometimes lead to the lawsuit. So again, I don't have to impress you, on this group, but believe me, there's groups in there where, I have agents every day they call me, and say, well, I didn't get this signed, I didn't get that signed, or they try to backdate. I'll get to that with the lead paint. That's just no. But anyway, and it happens every day. Every closing, I come with the lead paint disclosure, and agents at that time say, I need everybody to sign it. If you're doing it at that time, I try to always tell brokers, even if I'm not representing them at the closing, you shouldn't be doing this, because it's just not, allowed, one, by the agency law, two, by, the EPA. I'll get
Do we all hear that?
I'm
Do we all hear that? It's not done at the closing.
And again, you don't have it in the materials, but I'm going to bullet point my article. The fines are substantial if you get audited, and they do. The EPA a few years ago was actually going out a lot more. I think it's toned down a little bit over because of the environment, the economic crisis, and the cuts in government spending and stuff like that. But once they ramp it up again, these are nice little stream of income that they can just start auditing brokerage firms and saying, if see if you have the lead paint executed the right way. But I'll get to that when I get to the lead paint. Again, there's no reference in the real property law that says you have to get written agreements in place. Realtors, the Article 9 of the Realtor Code of Ethics, can't force you, but it also says whenever possible. Those are the trigger words. So, for the most part, I would say 99% of the times you have to try to get it. In the few times where you can't, or the seller refuses, then obviously you can cover yourself that way. Accordingly, while New York, while it doesn't require it, there's cases every day, and that's some of the materials, the supplemental materials that I didn't want to add to here because I actually wrote an article that's getting published in January's edition of Real Estate in Depth, so I can't really use it until it gets published and then use it. But if you read the next month's article, it really touches upon two issues: who you're representing, whether you're representing all the same party, the right parties. Sometimes you have divorces involved, and you think you're representing just a husband or a wife, or sometimes there's a son involved or a father, and it comes to you and says, I have the right to sell this property, and the broker can look into who really the owner is. And they can go to contract. We'll see one of the cases that I referenced. goes to contract, they sign it, and then the son says, I'm not signing. I never agreed to this. Now all of a sudden you have not only a BOS possible complaint, but you have a lawsuit, for commissions and saying, well, I didn't know. But don't worry, if you read my article, it's less dire for brokers than it sounds. So again, you have to get disclosures on a sale or a rental. Okay, they're required on those transactions. There are separate forms that are set forth in 443. There's one for a landlord tenant. There's one for a buyer seller. It hasn't been introduced yet, but we think it's a good thing. I started trying to push it a little bit. That there's 2 hours of agency law, agency-related CE requirements built into the 22.5 hours. Right now, there is no specific agency law, requirement. And I think it's helpful. I know that everybody takes continuing education and it's touched upon, but sometimes, if you don't have to take the agency courses and you can just get the 22.5 hours in, this may be a good, piece of legislation that forces brokerage firms to, make sure that their agents and everyone, actually know what the fiduciary responsibilities are and what the agency law requires. And again, as I touched upon before, there's no actual definition in the real property law. There's really only in the regs that were issued by the BOS. So we're trying to push, definition, of agency. You would think that there's somewhere in the real property law that they would define what an agent is. Not there. You have to actually go in different areas of the law, different case law, pull it up, see what's been decided, and see what, is required of the agency. And again, you have all the forms. I don't have to, I included them in the package in the outline. But if we're going to just go quickly through a bullet point of what agency is. How is it created? It's created by agreement, and it could be actual or implied. Again, it could be written, or just by the circumstances, it could be a verbal contract, or by the actions of the parties. When an individual principal designates someone to act, that's called an agency relationship, okay? Under the law, a real estate agent is only a specific agent for a specific limited purpose. Sometimes you have an agent who can sign on behalf, if I'm a trustee and I represent the trust, I can sign on behalf of that trust. If I'm a power of attorney and I'm an attorney in fact, I'm an agent, I can sign. Real estate agents don't have the right to sign on behalf of clients, but they are held to all of the other standards. And I'm just going to go quickly through. You have the duty of care, okay? It requires that a real estate agent have the requisite skill and expertise to fulfill fiduciary obligations. That's why we're here today. You have to keep up on the CE. So the number one allegation, whether it's a complaint or not, the BOS says, show me what your CE requirements are. That you've met them. Because if not, they're automatically checking to make sure you take, you've documented all of your CE requirements. Confidentiality requires that the agent not disclose confidential information when the principal imparts to the agent any confidential information that the agent imparts, that's been imparted to the agent. The obligation of confidentiality accrues, at the very beginning of the relationship. So whether or not you've entered into the disclosure yet, you still got to be wary that you may have not given them a disclosure form, but you still may be under an obligation, implied, not actual, to keep information confidential, okay? Undivided loyalty, which basically comes out if there's a dual agency situation, but that's one of the fiduciary responsibilities. Undivided loyalty in a fiduciary context requires that the agent place the interest of the client above the agent's own interest and anyone else's interest. So before you make a decision, what do? You don't say, is it good for me? Right? You don't say, oh my God, I'm going to lose my commission. oh, I gotta keep this deal intact. You say, what would my seller want? And that's the primary focus. Any decision that's made, you gotta make sure that you are the client. Put yourself in the seller's position. Hard to do sometimes because really, you're motivated by economics and you're motivated by legal, responsibility. I can tell you, you just represented, an attorney before the grievance committee. Everything he did in his fiduciary responsibility, okay, was to try to help people. Everything he did at law was law. Okay, so sometimes you have to just step back and really, if there's an issue, you may not want to take on the representation. So that's, you have to, sometimes the commission is not going to be the primary goal. The primary goal is to make sure that you're a great salesperson, a great broker, and a great associate sales broker. That's what you're here for. If there's an issue, the client comes first. You have to be obedient. You have the duty to account. So if here, less so, northern counties more so, if the agent has money that they take in, binder, down here the practice is a little different than upstate, but if there's a binder, you have the duty to account. So that money really, just like an escrow agent, when I hold money in my fiduciary account, the escrow account, I can't touch it. So no matter what I do, I've seen attorneys send out letters, I'm releasing the down payment, and then the attorney gets named in the lawsuit for breaching their responsibilities. It's funny because under the law, the attorney should never represent a buyer or a seller in any representation, capacity. It's not like the agency law for realtors where you can do dual agency. We're strictly forbidden. The only area where we're not is when we hold down payments. We actually represent both parties. So think about it. I'm representing the buyer or the seller. If I'm representing the seller, I have $30,000 in an account. I know my seller's right. I want to give the money back to my seller. I send demand letters and default letters and time of the essence letters, and I get a letter back saying, don't you dare release the money. That's it, I'm done. And I explain that to my clients because sometimes the client says, you're holding the money, so if something goes wrong, I get it, right? I have that conversation every time. And I say, no, I'm holding the money. If anything goes wrong, you go to court. And then 5 years later, we figure out how I get to release the money. And if I don't really want to hold the money for 5 years, I just give it to the court, deposit, and wash my hands of it. And you also have to do the full disclosure. Those are the basic principles, okay? So if you breach those fiduciary duties, you can lose the right to claim a commission. Absolutely, okay? You won't have a claim for a commission. You can lose the license, and obviously there's other disciplinary actions, and also lawsuits, civil litigation. And normally the trigger words are incompetent and untrustworthy. That's in every complaint, every settlement agreement that I have. Most of the times, my agents and brokers don't want to, admit that you have to, to get a settlement. Sometimes we say we acted in an untrustworthy or, incompetent manner, or we apologize sincerely, we're going to do it again, but a risk, we get a fine and move on. Sometimes it's we're taking your license away. So you have to be very, very careful. And again, the materials here, I would love to just keep going through all of it because it's great, but we have to just, keep pushing ahead. Lead paint regulations, I'm going to just go quickly, okay?
Do we just want to answer if you need questions?
Oh, yes, I'm sorry.
Quick question on an email. How should we be signing that if it's to a client or to another broker
So you gotta make sure, and you can do this when you get back, you know, make sure there should be a standard email signature in, just as a policy of your office. If there isn't, or you're just, you set up your own signature pad, you should make sure that it's in compliance with the address. And the compliance officer can take care of that.
What about like a broker, a salesperson to salesperson? Almost like a nonsense letter, I'll meet you at such and such a time, such and such a place.
You handle it just like you would a phone call. I mean, you just gotta be, if it's a salesperson to salesperson, it really doesn't. Yeah.
You have an email signature to do that. On your text, on my text signature, it says no reply, like, no sample.
Right.
Okay, so every text, even if I'm saying personal text, unfortunately, they get no reply, like.
Yeah.
But just, so it's covered, you're just, like not like before, you can never over use it, okay? So you better just cover yourself, use the same one all the time.
Yeah, like I said, everything that Rosemary said, everything that applies to an advertising or a business card, that's what you have to follow. It's pretty simple. Lead-based paint, I'm just gonna go quickly through it. It requires that we disclose on every residential sale or lease for properties built before 1978. There is a little bit of a distinction between a landlord tenant form and a seller buyer form, but pretty much they're almost identical except for some verbiage. So you got to make sure, one, that you're using the correct form if you're doing a lease, transaction or negotiation, or if you're doing a sale, a property sale. Sellers, as well as listing agents hired by the sellers to market the property, must comply with the requirements. So, it's not just the agent that has to provide this information. I'm an agent. In my article, I point out the law does not really tell us who the agent is. It doesn't say real estate agents, attorneys. It says agent. And so agent to me means any person who's representing a client or a customer, a person on a fiduciary agency capacity. So why do you see the brokers entering into this, give all of the lead paint disclosures at initial, signing with these 443 disclosures and all that? Because it says agent. Why do you see attorneys attached on every single contract a copy of the lead paint rider? Because it says agent. So at the closing, there may be 16 different lead paint, forms signed. The attorneys have to do it because we're required by law. The agents have to do it because we're required by law. We do it at a different point in time that you guys do it, right? So if you do it, you're going to do it at initial contact. I can't do it at my initial contact. That's when I do it, right? So if they're coming in and I send the contract out to the other side, boom, I put in my, the verbiage, I attach the lead paint rider, I print out the copy of the lead paint pamphlet, and it goes out on every single contract. You don't know how many times I get a contract back, and it doesn't have it on there. And then I have to add it in. I'm an agent, so if the seller doesn't provide it to me, I still have to provide it to my client, right? So if you're a buyer or a seller, just provide it. It's the simplest way, you get it signed. The problem I have, and I pointed it out earlier, at the closing is not the time. I can guarantee you somebody's going to get burned because you're going to have someone who knows the law and is going to say an issue arises or a dispute arises, and the attorney or somebody there is going to say he was circulating, make that as part of your complaint, and it's not a good thing.
If you have a specific case or something about that, like, we are very out of compliance in this area, okay? Diane has been reviewing the file, and we have a little kind of too, and people are getting signed for closing. Or there are initials or signatures that are missing on the form, okay, even initials. And was there something about this that they're finding the initials are not there?
Yeah, they're doing, they basically look at a lot of these issues, and when they, it was a DOS decision, the initial wasn't on there. They were basically saying they didn't have any information, so they basically gave this lead paint rider out. I didn't include it in the materials, but I can send you the actual case. I'll send it to Roland Rich. You can send it out. But basically,
No, I want to make a suggestion, because it's so easy if you use the system. If you're the listing agent, whether for a house up that is being sold or a rental, all you have to do is upload the lead paint into the documents in MLS, and then when you have it set it off, you simply tell the agent, download the lead paint disclosure and have it signed.
you know, and again, sometimes you gotta have, see, for me, I never get the sales agent to sign the disclosure, because they're not part of the contract, you know, negotiation. So my form on the contract usually is just gonna have the seller and the buyer. What I normally do is I try to do, when I engage a broker, you know, the broker sends me the memo of sale, I ask them to send me the lead paint rider, so I have it in my form, so I have their signatures on it as well. So at least I know everyone's in compliance. But, you know, it still happens. So the particular case was that they found the person, one, untrustworthy and incompetent for providing this lead paint disclosure, failing to put in the initials. They didn't even have initials in the right spot. There was a case where basically the buyer said nobody told us about, you know, the lead paint being in there. It was a public record, okay? But the fact of the matter exists. Obviously, in New York, caveat emptor is, you know, buyer beware. Once you close, it's really on the buyers, you know, unless there's two instances, active concealment or fraudulent misrepresentation. So other than that, once we close, buyers really have a hard time in court trying to, you know, get a seller on the hook for anything prior to the closing. But in this particular instance, there was information on file, you know, with the town regarding lead paint issues related to this real property. The problem is that has nothing to do with the DOS looking to see if you're actually filling out the forms and having the information correct. And if you're leaving out initials and that's what you have, you didn't explain to the buyer or the seller, whoever you represent, that this is what you have to initial. So if they're leaving it blank, obviously means nothing, because they're not saying whether there is or there isn't, and whether they were provided as a pamphlet or whether they weren't. So you got to make sure that you, when you get it signed, you know, an X is not good. Okay, I see them come over to me. Attorneys do it all the time. They'll send me the form with X's already in. I just have my client's initial on my side, if I'm a buyer or seller, next to the X. Do not use X's. Make sure that they're all initial. I think on the form it says, you know, check here. If it says check here on one spot, you can check it below where it says where you provided. Those need initials. Okay, so don't think, oh, it says check here, and then you can just check the rest. You actually, my practice, wherever it even says check, have the client sign it. It makes no difference. I mean, you know, obviously you want to, you know, do it real quick. You want to make sure it gets done, you know, efficiently. Having a person initial rather than doing a check mark is not going to cause, you know, any significant delay. So basically, yeah.
If you do a foreclosure, and I don't know if I can answer it at this point, they don't sign the legislation, they put it in their contract, is that okay?
If you're representing a client on a foreclosure, you have to disclose, you have to still give the lead paint. Yeah, absolutely, absolutely. Foreclosure doesn't really mean much other than if you represent the seller on a foreclosed property, you have to give it. If you represent the buyer on the foreclosure, you have to give it. It doesn't alleviate any responsibility when out of it. It's no. So that's basically lead paint. If you need, you know, additional guidance, I'm going to make available the article. Just we're getting short on time. We're going to take a few minutes. Actually, we have a couple more minutes. Let's go right to 10:45, and then we'll take a little bit of time. This is a huge. Yeah, this is huge, but it's you know it's quick to go through. The attorney approval clause. We have different areas that Rotary's office, you know, covers. Okay. So we have offices that may still be using a bar, a joint bar association, and realtor board Maybe.
Yeah, maybe capital.
Yeah, up there they still, I know for sure they still use it. That's why I mentioned it, just said it at the beginning. So for the most part, it doesn't apply to us when it comes to contracts, right? So if we have a contract and it's a broker prepared contract, which means it was approved by the broker, by the real property section, bar association, and also the local board of realtors. If it's not approved by those two entities, it's not allowed to be a broker prepared contract at all. And again, I host the police too, and I know that there's brokers and you know, sales agents that just take the form we sell, fill in stuff, prepare a one-page rider saying it includes this, doesn't include that, includes this, and send it out. You are actually, that's a criminal violation, it's a misdemeanor to do that. If it doesn't say at the top, you know, prepared by the real property section and the local board, you know, the bar association and the local realtor board, can't use it, okay? Owners can do whatever they want. If they have a form and they want to give it to a tenant, they can do it. If you get involved and you start, one case, this was a DOS decision, probably back, I would say 7 or 8 years ago. The broker lost her license because she wrote in no pets. Or, the buyer, she was representing the buyer. Well, the firm was representing the seller, she was also preparing this lease. And the lease basically said, no, you know, no pets. The buyer had a pet. Her handwriting in there saying no pets was determined to be by the DOS, her engaging in the unlawful practice of law. Just writing those words in there. So, I mean, that's extreme, but I'm saying if there's any thought process that goes on, and I'm not trying to, you know, it's got to be like, fill out the form for dummies. I mean, that's how basic you can do it. So if there's a form and it's prepared, the most you can do is put in names, contract price, if there's a mortgage contingency. These are mostly applied to, you know, the bar association forms that are prepared in other towns. Here we tried to push the bar and real estate contract back in the late 90s and early 2000s. That went through. They actually got it prepared, and was a significant, you know, key to that. Pushed it through the bar association and the real property section, and it never went anywhere. They actually haven't. There's an approved form. It's in my files that we could use. No broker down here ever used it. And just
Well, actually, brokers did use it.
for very
But then the attorneys just take it and make their own contract on top.
right. Well, what happened there was most of the attorneys were getting it, and then would just add a 50-page rider. So, you know, basically just taking it out.
If you were to add language that said this lease is required to be reviewed by an attorney.
Again,
Okay.
yeah. Oh, it's back up. Okay.